The next thing you've got to do is stare at this slide, boundary disputes. The land registry red line is not the legal boundary. Now, sharing this nugget of truth with your client will probably send them into a tizzy because they've just assumed, as everybody does, that surely it's the land registry that is the guardian of truth and honesty over the size and the scope of their land. But the answer is no, because in about 1875, 1925, they decided not to adopt the excellent, reasonable, and sensible cadastral system that Napoleon brought in, where everything is measured to within a centimetre and is accurately recorded at a central registry, usually the mayor's office. And if you want to sell off a piece of land, you won't be able to get a notaire to act for you unless you agreed the boundary to an accuracy of 1 centimetre. This was seen as being too expensive and too complicated, and fair to say that in France, if you have to pay land registry fees or the equivalent, it's going to cost you £10,000 rather than 200 quid. And so but it isn't any quicker. It still takes the land registry a couple of years to register something, and it would be nice if they could be accurate. So you have to disabuse your client, and sometimes the other solicitor, especially if they're a dyed-in-the-wool residential conveyancer who's never done litigation, that they just all assume that this red line is your boundary. The other thing is to think about site visits. It's absolutely vital that you understand what is on the site, that you personally understand the physical position of relevant things on the site. And even if the client's taken pictures with their mobile phone, you may well find that they've been selective in taking pictures of things that support their case, and they haven't told you about the things that actually against their case. I was talking to a property litigator who said they had a case where it was a negligence case against a firm of solicitors who'd acted on a boundary dispute because neither the solicitor had refused to go and visit the site, and it went all the way to the High Court, and the High Court judge said, I'm going to go and visit the site. When he visits the site, he says, it's abundantly obvious that this case should never have been started. It is obvious, looking at the physical features, that this road is here, and this path is here, and this fence is here. This has all been a complete waste of time, meaning that the solicitors in question lost the case and ended up wearing a costs claim of £250,000 because they had to pay the other side's costs.